examples and webinars and things for new school groups looking at trying to open a school, get their application written, and all of the things that entails. And I've asked Brad Miller, who's an attorney in Colorado Springs that has worked extensively with charter schools, and Tom McMillan, who also has a legal background and the director of choice programming for Douglas County Schools, if they would go over the legal aspects of what to look for when you're negotiating your charter school contract. So I want to thank them so much for doing this session for us, and I'm going to turn it over to them for right now.
Thanks, Kathy. This is Tom McMillan. Thanks, everybody, for joining us. And I want to flip, before we lose Kathy, to the next slide and ask Kathy to sort of walk the participants through this slide, because there are lots of great resources that you're going to want to refer to after today to help you get your arms around this whole contracting process. So, Kathy, can you speak to this slide?
Absolutely, I'd love to. This is actually a website that was set up to walk new groups through what the process is to open a school, and it's chock full of resource links so that you can do a lot of research on your own and just get to know the landscape of what it means to try to open a charter school, but also the different requirements and different information that you'll need to know, and good connections for that. So if you look through here, it's not really a timeline even, it's more a flow chart of what you need to consider in opening your school, and just kind of works you down through the process of putting an application together, turning it in for approval, and getting your school open. And within this link, there's also a link to the standard application, which was developed along with the flowchart in conjunction with the Colorado Department of Education, and we worked with the Charter School Institute at the time that we first initiated both this website and the standard application format, and they've both gone through some revisions and are updated to more current practices and whatever legal changes have happened. And within that website, there's also the model contract document, which is the example of things to look for in your contract when you're negotiating with your district, which is what Tom and Brad will be going over this morning. And so I'm going to again turn it back to them.
Great. Thanks, Kathy. And one question that I had as we're about to get started here, if you can indulge me, in the chat box, if you all could just let us know what stage in the process you are. Do you have an application that you're drafting? Do you have an application that has been submitted but not approved yet? Do you have an application that's been approved? If you could just put in the chat box at what stage you are in this process, that would certainly help me out to know how best to answer questions. So while you do that, Brad, would you be willing to jump in sort of the underpinning philosophy that drives a lot of these contract provisions?
Yeah, sure thing. And let's, if you don't mind, let's start with a brief introduction. As Kathy alleged, it's true, I am a lawyer. I'm sorry about that in advance. But, you know, what's the difference between a lawyer and a charter liaison? And Tom will appreciate this. Lawyers know that they're boring. Tom's going to have to get that figured out for himself. But I've been involved for 15 years.
I fell asleep, Brad. What did you say? I'm sorry, I just fell asleep while you were talking.
I really enjoy working with Tom. He's an excellent liaison working out of Douglas County, and is a fantastic support for the charter schools there. And I've had the pleasure of working with him on multiple things. I am right now at this point working with 7 different charter schools in various stages of the application or the contracting process. So this is something I do quite a bit. My 4 children all went through a charter. My wife worked at a charter. My mother-in-law was the first charter principal first woman charter principal, I think, or something like that. She's been around doing this for a long time. So this is my lifeblood, and I appreciate you all participating in this. So charter school philosophies. so there's always multiple interests at work at the state level or in the district level or in your school related to, why do we have charters, and this gets embedded into the chartering, the application process certainly, and the expectations of your authorizer, and what is it that you're bringing to the table that's going to improve education in your geography. Fundamentally, we're looking in charters for autonomy, and in exchange for that, we're willing to offer great accountability, particularly to good authorizers like Tom and Dougco. We define that through our charter contract, and so it's really important at the outset to get this right. We do want to be creative. We do want to try new things, and charters ought to have that freedom. Philosophically, we charters have been established in order to encourage innovation and to encourage improvement through competition, frankly, with the districts. And so we want to remain in that phase, be market-driven. We want to be outcome-driven. We want to create or work with families to bring children to their fullest potential, and we want to meet needs that aren't being necessarily met by the districts. And districts increasingly are pressing for us in the application process to demonstrate how we're unique. How do we bring something that really is choice to the district, and maybe not, and more than just an escape or something that is serving the needs of an EMO or an ESP. We've got to be serious about meeting special needs, and that's on both ends or all ends of the spectrum. And very much increasingly, at this point in history, there's quite a lot of discussion at all levels of interest in education about what does it mean to be responsible as a charter school, and how do we measure and how do we work with unsuccessful schools. And so this dialogue has just been very much at the forefront, and the League has been a very strong leader in helping to develop this narrative. But this is going on in the legislature today and tomorrow, and for the rest of this session. It's a big factor of what's going on in education now.
Thanks, Brad. So the philosophy that Brad has gone through should be reflected in the charter contract between you and your authorizer. The reason we say authorizer is that some folks go to their local district. Most people go to their local district as their authorizer. Some of you may be applying to the Charter School Institute, which is not a district, but it is an authorizer. So we just use the word authorizer sort of generically as the entity that you have a contract with. And so when you have this charter contract between yourselves and your authorizer, that's going to be between your board and the board of the authorizer. So it's important to remember, I think, that when you're working with your boards, to remind them and underscore the fact that they are the ones that are signing the charter contract, not the head of school. And your board is the one that the authorizer is going to look to for accountability and communication and transparency. So I just wanted to sort of underscore that going forward. So the idea of the charter contract is the tool that brings your school into existence legally, and gives it the framework and the structure for going forward and defines the relationship between you and your authorizer. So the idea is to establish a transparent relationship between the parties so everybody understands the contract requirements, everybody understands whose rights and responsibilities belong to whom. The idea is to promote collaboration and success of the charter school. No authorizer wants to authorize a school that's destined to fail. And so we are very careful here in Douglas County, and all of my colleagues around the state are very careful to authorize quality charters, not just anybody that comes down the pike, and that will be reflected in the charter contract. The charter contract incorporates your application by reference. So in other words, when you say in your charter application, well, we're going to show more than 1 year's growth in 1 year's time, and we're going to do all of these other things in terms of student achievement and financial transparency and all of that in your application, that's going to be incorporated by reference into your charter contract. So I think it's important, and Brad can speak to this, I think it's important when you're writing your application to be thinking, okay, can we really stand behind this? If this were a contract, does this go beyond hopes and dreams? Is this something we really think we can do because it's going to be incorporated by reference into our contract? Outcomes are more important than process. What authorizers, I'm just speaking with my authorizer hat on, and then Brad will jump in. We're concerned that you accomplish what you set out to accomplish more so than how you get there, with some exceptions. But in essence, we want to look at the bottom line just like you do. The contract should be real clear on everybody's rights and responsibilities. The charter school has responsibilities to the authorizer, and the authorizer has responsibilities back to the charter school. And those should be outlined in the contract. Also, the authorizers and the school's unique circumstances. If you have a particularly unusual design or forward-thinking design, different design, those criteria should be reflected in the contract. Outlining financial matters and clarifying waivers. And then I'm going to come back to this slide in just a second and let Brad comment, but I wanted to move to this one real quickly because, again, you remember when Brad outlined the underlying philosophy, it's this contract, it's this exchange or this balance between oversight by the authority, by the authorizer, and autonomy on the part of the charter school. And that's kind of a seesaw. Those two things need to be in balance, and they need to be, the contracts need to be user-friendly so you know what the heck you're agreeing to and what your responsibilities are. So let me jump back to the prior slide and see if Brad has some comments about these things.
Right, and thank you, Tom. So every aspect of a charter contract, although they are set forth in a standard form, every aspect is negotiable. And to Tom's point about the incorporation of your application into the contract, do be cognizant of this. If you assert, for example, that you're going to only be a K-8 school in your application, that's going to become part of the contract, and if later you want to grow grades above that, you're going to have some challenges with that. But everything from financial matters, who's going to pay the lion's share of special education costs and how's that going to work, what waivers will you be able to obtain in addition to the standard or the automatic waivers, and we'll have to talk more in depth about waivers later. All of these things are negotiable, and there is speaking from the charter's perspective as opposed to the authorizer's perspective, as we go forward in this, we should be aware that the State Board of Education is a backstop to challenges that we might run into with an authorizer that wants to impose conditions that may seem or feel unfair or may in fact be unfair. And so you do have a little bit of leverage in this negotiating process because there's a mama daddy back there that can help you to work it out with your authorizer if you come to some sort of impasse.
So I'll jump in, and I'm so grateful that Brad is part of this conversation because I've had the privilege of working with him for several years now on a bunch of different applications and working with different schools, both in application form and up and running. And I just want to underscore, you need to have somebody on board when you're looking at negotiating your contract with your authorizer, somebody like Brad.
If I may interject, if any of you are working with an ESP, would you type that into the chat as well so we can be aware of that, a service provider? Sorry, Tom.
Thank you. I forgot about that. Thanks, Brad. So it's very important to have legal counsel, not just somebody on your board, but as an authorizer, I prefer independent legal counsel to come alongside so that the lawyers in your authorizer's office and your attorney can be negotiating things back and forth. If you're a typical charter school applicant, you're so excited that your application got approved that you may be tempted to sign off on anything. And Brad will tell you that that's not a good idea. So,
increasingly there's a threshold issue that I didn't see reflected elsewhere in our PowerPoint, and that falls on me because I contributed to putting this together. But I have seen recently, and I'll say recently as the last couple of years, as authorizers have looked at applications, they have conditionally approved applications. And so at the board level, the authorizer will establish conditions that are beyond the scope of what was in the application. And this is a really important new development that as we negotiate these, we need to be cognizant of, because these superimposed conditions are something that are appealable to the State Board of Education, as I referred to before, but it's a change in the approach that districts have adopted, and something to be heads up on.
Yeah. And so I can speak to that. In Douglas County, we will generally approve an application as is, but then we will have conditions on the charter contract approval. So, for example, you may have an approved application, but you don't know where you're going to locate your school yet, which is very common, of course. So we would approve the application, but then we would say, well, there are contingencies to the contract that say you have to have X number of kids signed up by such and such a date. You have to have a location lease or purchase agreement by such and such a date. And so generally what we'll do in Douglas County is we'll approve the application and then we'll approve the contract with contingencies. And so that may be a little wrinkle on what Brad was saying, but you can anticipate those kinds of things and be communicating with your authorizer right on through the application process, I think, to kind of get a feel for where they are and what kinds of contingencies they might be looking at.
And I agree, and I think it's a healthy development, and yet it's a development that we need to be very cognizant of as we're actually doing the contract, because sometimes the conditions aren't directly and word for word incorporated into the contract, and so then you've got this deal where the board's resolution says one thing and your contract says something else, and you need to make sure you've got clarity. I've just been running into that quite a bit lately. And if you don't mind, I'll continue along those lines and suggest that the bullet here that says charter versus contract and the different legal views, there are some authorizers who will look at the statute that talks about an initial charter should be for 4 years at minimum, and they'll say, okay, we've awarded a charter, and so you've applied this summer 2016, and they'll say your charter started in August of 2016. You've got 4 years from now until the next renewal, and the contract will be for a different duration. And so this is something where a lawyer can help you navigate that one, but that's been an interesting development as well.
Yeah, that's a good point. The statute, help me out here, Brad, but the statute suggests an initial term of at least 4 years. In Douglas County, we generally go 5, and we don't make a distinction between charter and contract. But that's a good question to ask your authorizer going forward. So,
because some will take the perspective that the date of their board vote to approve a charter starts a 4-year charter sequence, and so the resulting contract is only 3 years by the time we get rolling.
Yeah. Oh, sorry, my screen fell asleep. Brad, do you want to talk about EMO and service providers and the 5% withholding? Do you want to talk about that now, or?
Sure. So it doesn't look like anyone on the call currently is working with a full service provider. This is certainly an area where authorizers are going to be reasonably attentive, going to want to ensure that you devise a fair arm's length contract for the services. And on the road, if you do some back office support, there's firms out there that offer that. I maintain that working with your authorizer, working with the Tom McMillan, if you're in DougCo, to have the authorizer help you leverage these contracts is a very helpful approach. There's several national style EMOs or ESPs that have a standard contract for their service agreement, and that too can and ought to be negotiated, and it ought to be done with separate separate council. And so that's just a very important factor going forward. And you want to get that right. Any of you that are in the application phase right now, now's the time to get that straightened away, not after. There is a statutory 5% administrative fee that will be in some measure incorporated in the contract. And this is an oversight fee that the district is entitled to withhold or have returned to them depending on the way the money flows. I've never followed that too carefully. But it's up to 5%, and it has to be based on actual costs expended in the oversight and support of the charter school. This is not a fee for direct services such as counselors or other supports in the SPED area or transportation or any of that. This is fees that are related to holding you accountable, making sure the correct reports are submitted on the correct times. It's administrative supports. You are, as a charter school, are entitled to understand that fee, understand what they're calculating. It shouldn't just be X percent of all these different administrators if they're not actually providing services to you. And so this is one that you can push back and forth down the road as well. Oftentimes, the initial contract will set a first-year fee and then negotiate that fee based on actual expenses later in the contract.
Yeah, and by law, you also have the right as a school to receive a yearly accounting for where that 5% went, as Brad has mentioned. And so that's one of the items that may or may not be reflected in the contract, but which is a legal requirement that you can hold your authorizer to, that you get a yearly accounting for what they did with that 5% or however much it is that they're withholding, up to 5%.
So the next bullet is very meaningful. It is critical that from this point forward, each of you that's applying, each of you that's in the contracting phase, stay in contact with your liaison, your contact at the district or CSI. There really is nothing better than in meeting people face-to-face and dealing with real problems in genuine terms rather than arm's length through a piece of paper. It's just very important. You start now with routine updates to your liaison or whoever you're supplying the application to. Let them know where you are in the status. Let them know what the relationship with your ESP is evolving to look like. Make sure they're updated if you've got changes on your board composition. All of these things are really, really helpful.
Yeah, I just want to underscore that fact. It really helps to have somebody like Brad on board. We have an application pending right now in Douglas County, and Brad and I are already talking about some of the provisions that we had some questions about or some thoughts about. And, you know, the application just came in 2 weeks ago. And so it's really great if you can find somebody like Brad who's got good relationships with your authorizers to start those conversations early. So that you don't get a surprise at the tail end of things. So, also, the last bullet, if I can speak to this, the state board has adopted as guidance authorizer quality standards to which authorizers themselves should be held accountable. There's an organization you may have heard of called the National Association of Charter School Authorizers, NACSA. NACSA has quality standards that they have adopted, and they've encouraged local school districts and CSI to adopt those same standards, which a lot of us have done, including here in Douglas County. And those quality standards are not mandatory, but they are in state board rule as guidance for how authorizers should conduct themselves. So it would be interesting for you to ask your authorizer if they know about those quality standards and or if they have adopted them. That might be an interesting conversation to enter into with your authorizer.
Great.
So we're going to jump into the weeds here a little bit and actually talk about some of the sections of the standard contract or the model contract. The reason we're going to talk about this is different districts have different contracts. These will be kind of standard provisions that you might look for as you're working with your attorney to look into different contracts that you might be provided with by your authorizer. Not a bad idea to ask for a draft of a contract that they've got currently with a currently operating charter school because I would be surprised, Brad, you jump in, but I'd be surprised if they would vary very much from kind of a standard form that they use with almost everybody. That's certainly the case here.
No, that is correct, although sometimes there's districts that have authorized a new school in years and years. Maybe they're not big of a district, for example, and so, yeah, sometimes there's some variance, but you're exactly right. It's always helpful to look at the last charter that was approved and find their documents. It will give you lots of guidance.
So we're going to be going through each of these sections a little bit individually, but these are the sections that appear in the model contract or the standard contract. Introduction, establishment of the school, a description of the authorizer and school relationship. Section 4, a description of the school governance, what your board looks like, and requirements around corporate formation and keeping that entity going and operational. Section 5, operation of the school and waivers, and we'll talk more about waivers later. Section 6, school enrollment and demographics. Who are your kids and where are they coming from? And as Brad mentioned, if your application says K-8 and your contract says K-8, you would need a contract amendment down the road if you wanted to expand into high school. So just keep that in mind as we go forward. More sections, the educational program. What kind of a program is it? Is it core knowledge? Is it expeditionary learning? Is it artful learning? What is it? And how are you going to measure the achievement of your kids? Financial matters. These are issues like you have to have an independent audit every year and share it with your authorizer. There are a number of requirements in contracts around post-financial statements and other financial transparency issues. Personnel, who are you going to be hiring and where are they coming from, or are you hiring an outside entity, as Brad has referred to help you find those people? Section 10 is service contracts with the authorizer. So for example, here in Douglas County, there are a number of services which can be purchased back from the district. For example, food service. If you don't want to run your own food program, you can purchase from the district food services for your kids, and that would be in a separate contract outside this main contract. Section 11, facilities. Where are you going to be located and how will you arrange for those facilities? Are they district facilities you'll buy or lease from the district, or are you on your own outside? Section 12, renewal, revocation, and school-initiated closure. This talks about how to keep going or how to not keep going anymore. And then Section 13, general provisions, which is just sort of the catch-all and definitions. So anything you want to speak to before we go on with those, Brad?
I note that in our PowerPoint we don't have a lot of discussion about financial matters and how those are negotiated. And I just wanted to point out a couple things that you might want to look at in that regard. One would be if the district has an existing mill levy override measure, the only time you're going to get an opportunity to actually be included in any past measure is if you talk it through at this point when you're developing the contract. It's not always likely that you'll be successful there, but you may want to raise that issue. And then there are details around the way special education is supported that we may have a slide later to talk about that, but those two financial matters are critically important in this negotiation process.
Yeah, I think that's really important to point out, and thanks, Brad, because unlike some of these other things which have a lot of wiggle room in terms of negotiation, things like financial matters are governed a lot by state law and provision of special services to students, whether they're gifted and talented or special needs. A lot of that is also governed by state and federal law, and so it's important to understand who's got the responsibility for what in those areas. And I think we'll revisit those again a little bit later.
Okay.
So let's talk, I'll talk about the authorizer rights and responsibilities, and then Brad can talk about the other. So Section 3, this is defining the relationship. This is sort of the marriage between the authorizer and the school, and like with any good marriage, there's a lot of communication that needs to happen. So the authorizer retains the right to review what's going on at the school. This isn't just dropping in unannounced, but the authorizer will have the right to review financials as well as academic performance and other items just to make sure that the school is healthy and moving forward. This section also talks about how the authorizer will handle complaints that the authorizer receives about the school. And so it's really important as you're putting together your application to think about having a complaint process for how you handle complaints in the school. So if there's a complaint about the board, how is that handled? If there's a complaint about the principal or a teacher, how is that handled? Because one of the responsibilities of the authorizer is to send those complaints back to you rather than try to get involved in them unless there's a violation of contract or law. So it's important to be thinking about that. School health or safety issues, the authorizer is going to ask you to report up to them things like fire drills and shelter-in-place drills and security at your building. The authorizer has a right to provide you with feedback about academic progress, and if there are financial things that need to be tuned up, the authorizer retains the right to work with you to tune up those financial issues, as well as having access to student records. Authorizers have a lot of responsibilities to the state government and the federal government in reporting up your student achievement and demographics. And so one of the things that contracts will always have is the access by the authorizer to student records for specific uses, not just for whatever. So those uses will be tailored to authorizer responsibilities to the state and federal government.
So the school's got commensurate rights and responsibilities. With regard to records, there will be an aspect of your contract negotiation that goes to whether you will utilize the same student information system, for example, an Infinite Campus, and that's a decision to make at the contracting time. It's very helpful, but you've got to make sure that the SIS works for your approach, but it's helpful to be in the same system as your authorizer. But we do have an obligation to provide records. We're nonprofits under the Colorado Nonprofits Act. We have certain obligations in terms of maintaining records, and these are everything from the student records and employment records to finances and to things like board minutes and so forth. With regard to finances, if anyone is using an ESP or consider doing that, one thing I would highly recommend is that in working out a service agreement with the ESP that they agree to comply with the Colorado Financial Transparency Act so that all transactions and checkbooks can be compliantly posted on your website so that your community can see how money is being spent. But certainly the district has a right to know that as well. Notification provided to the authorizer might be a material change in operations and some specific notifications that will be enlisted in the contract that are date sensitive. We're obligated to comply with many of the same reportings that the school district does, and it's important in the contract to understand the difference between, well, that there are some reports that you can be waived out of, and so that waiver process is critical. For example, your employees likely will be at-will employees, and so the evaluation requirements are a little bit different. The reporting is a little bit different, even though all of that still goes into the same data pipeline that the district has to fill out. But we want to get clarity there. But again, the district will, in the contract, in the standard contract, will set out some dates for things like when do your enrollment projections and when is your budget adopted and all of these things. So quite a big list of things, but it is fairly standard, and so I think that's what I'd have to say about that.
Great. So again, some more in Section 3, talking about this marriage between the school and the authorizer. Section 3.3, indemnification, that just says you will hold one another harmless for anything that happens, and talk about that if he wants to. Procedures for articles of incorporation and bylaw amendments. Very often in the contracts, the authorizer will want to know at least, and I don't know about approve, you tell me, Brad, but in our contracts, we want to know if the school is amending their articles or bylaws so that we can see if those are, significant changes that would change the operation of the school. I don't know if some other contracts require prior approval by the authorizer or not, but we just ask for notice so we can review it and see if there's something contingent.
I'm sorry, I've walked on you. Reminds me of some sort of lawyer joke. but there are authorizers who will request in the contract, and you can negotiate on this, the right to approve if you change the membership status of your school, and that has to do with your nonprofit status and whether you're a member organization that gives your community the right to elect your board members, or whether you're a non-member that would not give that right. And so sometimes, at least in that respect, authorizers will ask to have an approval before that status changes. But generally speaking, they'll just say they want to know, they'll want to have notice of changes in these documents.
So then some other things that are in this Section 3, and then we'll get into a little more detail in a minute. How you go about resolving disputes between the school and the authorizer. Very often, at least in the standard provisions that I've seen, you don't go right to court. You work on mediation first. Each side gets to appoint a mediator, and they try to work it out. And so that'll be spelled out in the contract. Other remedies, for example, if something really horrible happens, the authorizer may have the ability to step in and run the school if something really bad happens, but that would be spelled out, and that would be a very narrow contingency for something like that to happen. And then what do you do if the authorizer violates charter school law or the contract? What are your remedies there? So I don't know if you want to speak to any of that, Brad, before we go down farther.
No, let's go ahead.
Okay. So some of these things we've already talked about a little bit, what the charter school's obligations and the authoriser's obligations are. So we won't necessarily dive too deep into this because we've kind of already talked about it. But here's a nice list for you to have handy. And again, this webinar is being recorded, and this PowerPoint is certainly available to you through the league after we're done. So
I will point out on this page, just under authorizer obligation, the obligation to notify the charter school when complaints about it are received. That's a healthy provision, and and Tom understands. Y'all should apply to Doug Coe because he does the best at this. But understanding the authorizer's role to not interfere with a community member's complaint, but to notify the charter and then redirect that community member to the charter school, because the governance does lie with you as opposed to with the authorizer. And this is a distinction that's hard for some districts to grapple with. So just pay attention, make sure that this provision is in there, and it's meaningful, and it sets up a relationship in which the district will receive and communicate to the charter school the complaints and issues that arise rather than trying to address them itself.
Yeah, thanks for saying that, Brad. Honestly, you know, the authorizer really doesn't want to get involved in a dispute between a parent and a charter school unless it appears that there's something illegal, immoral, or fattening going on. I say by jest, but really, you know, the only time that I want to get involved is if it looks like the charter school board is breaking the law or violating their contract. Apart from that, we're going to refer them back to the school board because it's the school board that has the authority and the autonomy to handle those complaints. So again, even though this is going to be reflected in your contract, it's real important in your application to have a real good, robust complaint procedure, or however you want to frame it, for handling complaints internally from your own parents, from your own teachers, from your own staff. Because, you know, if you've got that lined out, then the authorizer, we can sort of breathe a sigh of relief to say, we know how this is going to be handled when we refer it back to the school. So pay a lot of attention to that when you're writing your applications, and I know there are good examples out there.
For sure.
So
we'll
talk about
the contract will have the contract will have a provision that talks about intermediate steps and remedies that the authorizer can utilize when there are challenges, when there's performance issues, when there's operational things, when their finances are out of whack. And this is a healthy and good provision and set of provisions to have in here. Because back in the dark days, there was, before the model contract, there was often not really much of a menu of options for authorizers to utilize, and so they were faced with the prospect of either closing the charter school or putting up with the bad behavior. These provisions are very helpful to give options. And just be heads up, one of the options typically has to do with withholding funding until compliance is achieved.
Yeah, and that's sort of a nuclear option because, you know, it has to be pretty bad, in my view, for an authorizer to withhold funding because we know that's the lifeblood of the school. But it has happened. There have been situations where the authorizer literally meets out in the parking lot, check in hand, to make sure that the school is complying with whatever needs to happen. So sometimes that can happen. So. Okay, and feel free, if anybody has questions, feel free to throw them into the chat box, and Brad and I would be glad to try to answer them. So don't be shy. If you have questions about your application or anything going forward as we're talking, please throw them into the chat box. Okay. So let's talk about educational program a little bit. This is really the heart of how you're going to be serving your kids and how you hope to be teaching them. Now, a lot of this is going to be drawn, of course, from your charter application. If you're going to be a core knowledge school, if you're going to be expeditionary learning or whatever, this is the part of your contract that's going to set forth the vision and mission and the goals of your school. And so, again, some of this is going to be drawn from your application, but these parts are specifically written into the contract as opposed to coming out of the application by reference. So what are your school goals? What are your school objectives? What makes you different? What's your secret sauce? Such that if an authorizer finds that you have unfortunately gotten into what I call mission creep, where you started out as this kind of a school, but it's really not working, and now you want to become that kind of a school instead, your authorizer is going to be very interested in knowing that you're changing your educational program or your school objectives. So. Let's talk about some specifics. Brad, you want to speak to this?
Yeah, so as those of us that are in this application process right now, it looks like at least a couple of the present company are, be aware that the mission and vision that you adopt and that you include in your application will be incorporated into the contract. It will become a contract expectation. And so it is important to undertake that exercise thoughtfully. What do you want to look like? What's your culture going to be? What is your vision for what the school will be? And along those lines, that any characteristics that you want to incorporate, let's say that you might want to have an element of online education. Perhaps you want to grow into a preschool or a full-day kindergarten and when you started as a half-day. Perhaps it's something about grade expansion. These are a contract item at the outset, and so including them in your application will be helpful. And these characteristics will be adopted. And so, for example, if you don't suggest that you're going to be offer online courses, there will likely be an online exclusion in the contract saying that you may not provide online. So you'll be shuttled into the things that you propose.
approve of those contracts, but I sure would like to see them so that I can have input. Because again, just to go back to what we said right at the beginning, the contract is between the school board and the authorizer. And if you're contracting with an education service provider that has a real, back in the olden days we call them a contract of adhesion. In other words, you can't get out of it without basically crashing the school. I, as an authorizer, am going to be very interested in looking at that contract and examining that relationship up front.
Yeah, that's right. And I'm sorry, everyone, that I faded out. I actually had to plug my phone in, so that was the issue. It wasn't the webinar. The two last things I wanted to say on this one were you need to agree, you need to get an agreement with your ESP to permit you to participate in the Colorado Transparency Act, the requirements having to do with posting and making visible to your community the way monies are spent. And you need to understand that if you leave these poison pills in there, that a thoughtful authorizer is just going to simply deny the application because, as Tom said, they can't come in and interfere with they can't negotiate it for you, but if you don't negotiate it well yourselves, then it gives them a basis to deny the application altogether.
Yeah. Great. Thanks, Brad. So let's talk a little bit about what a material change is, and lawyers can argue about how many angels can dance on the head of a pin all day long, and this is another thing that we love to argue about. So Brad, what do you think a material change to an application or a contract would look like?
Well, some of the ones I've run into on both sides of the fence, and in full disclosure, I actually work as the counsel for a large district in El Paso County, as well as working mostly with charter schools. So I've seen it from both sides. One is an assumption by a charter school, or a desire by a charter school rather, that they'd like to expand their grade level options. They've been K-8, and suddenly they're seeing pressure from the parents of the older students to expand into high school. Well, a charter school isn't able to just do that without authorizer cooperation and approval. In the same way, a charter school may say, and this is not uncommon, the special education services being provided to us by the district aren't adequate. We're paying this insurance fee, and Bradford, we will cover how that works, but we're paying this, and we'd like to go out and hire our own director of special education. We'd like to do this ourselves. Well, you can't do that. That's a material change. Sometimes an authorizer will adopt the attitude that changing your bylaws is a material change, and I would argue strenuously that it is not. That it's not one, it may be material, but it's not the sort of material change that an authorizer should have the authority to authorize. Because if you go back to our philosophy and our basis for being, charter schools should and by law do have the authority and autonomy to make those sorts of decisions themselves.
I have a specific example.
And I'll give one more example because so authorizers will like to say that they have the authority to identify your auditor. That's not necessarily supportable in law, but it's something you can contract to agree to, but you don't necessarily have to as a charter school. And so some of the financial aspects, while they're very important and truly material, they're not material in the sense that they give the authorizer authority to intervene.
So I have a specific example of that. In my email inbox this morning, I have a complaint from a parent about one of our charter schools and the way their bylaws are written and how their board is constituted. That's interesting for me to read, but as you might guess, I'm going to send that right back to the school board because I don't have the authority to require them to change their bylaws based on a parent complaint. And I'm not going to do that. Now, I can encourage them to deal with that parent and hear out their concerns, but I'm certainly not going to require them to change their bylaws based on a parent complaint to the authorizer. That goes right back to the school. So,
right.
You want to talk about waivers?
So I want to talk generally, broadly about waivers, and then like you, Tom, to walk us through this slide. But the status of waivers for charter schools in Colorado is a bit in flux, and we need to keep our eyes out open for legislation right now, currently in the session, that might revise some of the automatic waivers, change the way waivers are dealt with by the Department of Education. But that said, waivers actually aren't a statutorily created being. What they are is something that have been adopted by the State Board of Education, and as such, a change in the composition of the State Board of Education could change the way this whole regime works, because currently there's this sort of there is certainly a majority of folks on the State Board that favor choice and charter schools, and as a result they've adopted a set of automatic waivers, and they're working on the functionality of those so it's a little bit less onerous to have those approved, and then they approve routinely a whole system of other waivers that don't make sense for a charter school to have, and that might look like something for the way you do you purchase services and the contracting and bid requirements that a district has, you might not need to have as a school. And so you can get waivers for these things that aren't automatic but make sense for you. But truth be known, the only reason why charter schools in Colorado don't have to be subjected to the teacher tenure acts and licensure requirements is because of these waivers. And so these waivers are very important to your operation and world. And everybody out there is really working hard to make this, what used to be a very onerous project, a little bit easier.
So thanks, Brad. So one of the changes that Brad's referring to is up until January of this year, for the automatic waivers that you just get automatically just because you're asking for them, those had to be submitted separately with a cover sheet and all kinds of stuff like that to CDE. Now, after your contract is signed and all put together, you will attach a list of automatic waivers as well as a list of non-automatic waivers to your contract, and you just send your contract to CDE. And the question then becomes, what happens then? Well, our hope is they look at it, check the box, and put it in a drawer, and that's it for the automatic waivers, certainly. But just to clarify for you, check in with your authorizer to make sure they're up to speed on that automatic waiver process. You just put them into your contract as an attachment, send the whole thing to CDE, and you should be done. There are also non-automatic waivers, and you can find information on waivers on the CDE website as well as through the league. There are also non-automatic waivers. For example, you might want a waiver from state law regarding your teacher licensure, if that's automatic. What's a good non-automatic? Maybe school days or something like that, so long as you're within the number of days that the law requires. So it's best to have all of those waivers, automatic and non-automatic, from state law put together all at the same time in your contract that you would negotiate with your authorizer, because then your authorizer just sends it in and they're done. When it comes to district policies, this is where I think it's really great, not only with state law waivers but also district waivers, to have your attorney go through and see which authorizer policies it makes sense to waive out of. So for example, there may be requirements about fees that you can charge, or textbooks, or what your school calendar should look like, or all kinds of district regulations that may be inapplicable or have negative consequences for your school. So you can ask for waivers from those district policies from your district as well, and that goes to the district board. And the district generally will sign off on those because, again, that's pretty standardized. Any thoughts about that, Brad?
I've seen that sometimes if districts are a little bit obstinate in approving these things, that it's super helpful to make sure that you've done your homework and you see what waivers previous boards of that district have approved for other charter schools in the district, and that's been pretty persuasive. So being attentive to what other people have done is very, very helpful. The State Board of Education is currently comprised is pretty eager to go ahead and approve waivers that are approvable. There's certainly some that you can't, and so a lot of times people ask the question, well, can we get out of the state assessments? The answer is no. There's specific areas of operation that are excluded. But again, looking at the track record of other people, and I think, Kathy may want to intervene, but I think the league actually publishes some examples of those sorts of waiver lists that people have put out, and I think CD actually has a list of commonly requested waivers.
Yep. Yep.
Yes, we do have samples that we could send.
Right.
Chris asked a question. House Bill 1343 would remove automatic status for 18 automatic waivers. Do you know the status of this bill? That's a great question for Dan at the league. My understanding is that there are all kinds of folks that are opposed to it, so I'm not sure where it's going to go. But I think Dan Schaller could answer that question later on. So,
well, I did have a conversation with Jessica at the league, and clearly the league is taking a position against this, and we can't, no one can predict for sure, but I think you're right. There are a good number of folks who have taken a position against this, and it probably is a right group of folks.
Yeah, it certainly goes 180 degrees in the opposite direction from where the state board is going in terms of making this process easier rather than harder. So I'm anticipating that bill won't go anywhere, but we'll keep an eye on it. Thanks, Chris. Good question. Good question.
Yeah.
So I think maybe we've already touched on this. Anything on this slide, Brad, you want to talk about?
No, just that second bullet is interesting. There are certain things that you don't actually have to get a waiver from. It's just you sort of are automatically not required to do certain things that fall under the district's obligations because you have a different nature, but take a lot of time to kind of delve into what that all is about. But there are some things that you don't actually have to specifically obtain a waiver for. You just are excluded.
Great. We want to spend a chunk of time talking about special education, and Bradford had asked about this previously, so let's spend some time about this because this is a very important area that's controlled not only by your contract but also by state and federal law, and who pays for what and who provides what services. So, Brad, you want to jump in?
Well, so the overview, we don't, as a charter school, under in almost every district, well, every district I've been associated with, we don't decide about a particular student whether or not they're going to be enrolled or admitted through whatever process we have, a lottery or what have you, based on disability. What we do is we enter them in, and then we take the time working with the authorizer, working with the special education department to determine whether that student's needs can be met at the charter school. So the rumor out there that charter schools somehow exclude students with disabilities is generally untrue. We've heard these anecdotes about people counseling students or families with these needs not to apply, but I don't know how much truth is around that. But we don't get that opportunity. We admit these students, and then we decide whether their needs can be met in the school. And so there's an IEP team, a screening team that involves school leadership and then the professionals that typically are provided by the district, and someone certainly from the authorizer in the event that you're doing your own special education. And they get together and they determine whether a plan should be implemented, whether it's an IEP or whether it's a 504 plan, which is a plan that would meet particular needs for students that aren't designated as special education per se, but they might have a need, maybe it's attentiveness or so forth, or vision, that you're going to give them a few special accommodations, maybe sitting in the front row, for example. So you make these determinations. In some cases, a district will say this student is better educated in a center-based program that the district may provide a certain school where all the students with a particular need are aggregated and better served. And so those students may not, in fact, enroll in your school. And so that's all addressed through these very specifically designed meetings and documentation and so forth. Now, to Bradford's question, different districts have adopted different approaches for how special education is provided. So assuming the student is enrolled in your school, many times the district will have what we refer to as an insurance approach to special education. And what they will do is they will agree that the district, will provide the services needed for special education students in your school, in your facility. And the way that this will be paid for is by taking into account all of the costs district-wide for special education needs, and then dividing that across the total number of students in the district. And that cost then is, so then let's say it costs $600 per student in the district, if all things are considered equal, to educate our special education students in the district. Then you, the school, will pay that $600 per head as a fee to the district in exchange for them taking on the entire challenge of whether, sorry, I had another phone go off here, whether or not you have 5 kids or 50 kids, whether you have a bunch of kids with moderate needs or a few with very severe needs, you would pay the same thing. It's insurance. But what happens mostly is that there's some sort of a hybrid of this plan. And so schools like a Montessori will say, we really have a unique approach to educating students. And we'd be more comfortable in our culture having the teachers be our own employees. They're doing professional development with our folks. And what we really need the district to do is provide those specialists, a hearing specialist, a sight specialist, maybe the nurses, almost always the nurses are provided by the district. And so there's a bit of a hybrid plan put into place. Douglas County, as an example, does I think their program is, they start out with this sort of the blanket insurance program, and then in subsequent years, after your first year, you can negotiate it out and sort of purchase a set of services. And so there's some critical factors here. If it's an insurance model, but it's a hybrid, you have your own special education teachers in the classroom for those kids who are mainstreamed for the most part. What happens if there's an OCR complaint or a state-level complaint, a legal issue that arises over the provision of services? Parents argue that you didn't do what you needed to, student service needs weren't met, and so the contract needs to address who's ultimately responsible financially for that. The district is ultimately responsible legally for it, but they can delegate to you the financial obligation if there's a problem like this. So in this contracting phase, in the model contract, there's sort of 2 options. One is for something that is the insured model, and then there's another one for pay-as-you-go. And that's the model language. Because there's so many hybrid versions and approaches, it's just absolutely essential that we approach this with legal counsel and understand it. I've probably spoken too long here. Tom, what would you add?
No, I think that's exactly right. This is a really critical area to have a very clear understanding with your authorizer what the expectations are in terms of serving students with special needs at your charter school. So, and it's a moving target. for example, Denver Public Schools has now begun to put center-based programs for kids with more significant needs into charter schools. And their DPS is now expecting charter schools to serve a full spectrum of kids with all different needs, not just mild or moderate needs, but also more significant needs. And so, if you're applying to DPS, be aware of that. DPS is now placing center-based programs for kids with more significant needs into charter schools. That's a new wrinkle and a new trend that you don't see in other authorizers, but it's certainly true for DPS. So one of the things that I would flag for you so that you don't get into trouble and you don't have accusations of counseling out or not taking kids is what we recommend our folks here in Douglas County to do is at the very beginning when you're collecting those letters of intent, even before your application is approved, but when you're collecting those letters of intent from interested parents, that you have a little box that they can check saying, has my student been receiving special services? And you can make it as generic as that. You probably don't want to say, is your kid on an IEP or a 504 plan or deaf, hard of hearing or whatever, but they could be English language learners, they could be gifted and talented. But you have a little box on the expression of intent form that says, has your student been receiving special services? And that way you can kind of flag that student so that when you pull your names in your lottery, when some of those come up, you can be ahead of the game in terms of examining what their special needs are to make sure that you can provide that student with a free and appropriate public education, which is the legal standard. So we've begun to ask some of our charters, even before a final decision of admission, to have those staffings, because you get extremely unhappy parents who have a student with special needs whose name came up in the lottery, and then, lo and behold, we really can't serve your student, and there are a lot of hard feelings and even legal consequences potentially to that. So, Brad, I don't know if you've seen that in other districts or not, but that's kind of the direction we're headed.
Yeah, no, I have seen that, and to bounce off of that, one thing that also occurs is that charter schools oftentimes will attract more students who reside outside of the district boundaries than is the case with the coordinated schools. And so what can happen in the special education framework is that there will be disputes about who's obligated to fund these students. And so there will be some interruptions from time to time about the enrollment of a kid who had a pre-existing IEP, enrolled in a different district, living in a different district, and whether or not that student can be admitted has to be coordinated with your authorizer.
Yeah.
So there's all sorts of permutations around this.
Yeah. And depending on your school model, if it's a different kind of a model, you may attract a disproportionate number of parents whose kids have special needs, whether they're gifted and talented or whether they have an IEP. And so, just kind of a heads up, depending on your school model, you may attract more kids than you expect. So it's good to be on the front end of that and be working with your authorizer up front to determine how you have those staffings, how you have those IEP meetings, and how you serve those kids. Because really, you want to serve every child that you possibly can, every student that you possibly can, but you also want to be sure that they're going to be successful, whatever educational environment that they're in. And that's where the authorizer and the charter school really do come together to say, what's in the best interest of this student? How can we best serve this student?
Absolutely. For what it's worth, a point of contention recently is that students with a particular set of needs are flocking to Colorado in order to access cannabinoid or THC products. And so be attentive as you're going down this road as to what policies your district has adopted with regard to that, because, boy, I've seen an interesting flux in that regard.
Yeah, very interesting. Okay, well, I think we've kind of come into the home stretch here. We've probably done just enough to make you dizzy and a little nauseous. But understand that the model contract that we've talked about today is just that. It's a model or a standard contract. You're going to see different provisions, but the goal for today was to sort of socialize you, so to speak, a little bit to the kinds of provisions you might see in your authorizer standard contract. And there's no reason not to give them a call now and say, hey, send me a copy of a current contract so I can see what kinds of things are in there, so that you can be reflecting those even in your application as you go forward. What do you think, Brad?
That communication piece is critical. I know we harped on it earlier, but do stay in contact. Develop a relationship with the person you're going to be working with for, the next number of years, and start off on the right foot and be in contact. All of these documents, all of the things we've talked about, are open public records that you may access. So you are entitled to see what the contract looks like with the last charter school that was approved, what their application looked like, what waivers they obtained, all of these things.
Yeah. Questions? Well, I know the League is ready to provide you with lots of support. This presentation has been recorded. You can also get a copy of the slides if you're interested in getting those from the League, and Kathy Zlomke or Lori Ventimiglia can help you out with any questions or any referrals that you need going forward. Bradford's got a...
Go ahead.
Great. Well, thanks to everybody for participating with Brad and me, and I know Brad would be happy to visit with any of you going forward, as would the folks at the League, and CDE also will be helpful.
Yes, and do feel free to reach out to us. We put these webinars on our website. If you go to coloradoleague.org, you'll see the Start a School section, and under Trainings and Webinars, we post the recorded webinars, and we are always happy to chat through questions with you or send you resources, connect you with folks that can help you. So feel free to reach out. Thanks so much for joining us.
All right,
thanks everyone.